Conley, can you start your video and unmute yourself, please? Calling the case number of SP4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy, because I would like to note two things. You're driving at a disgusting rate in a construction zone.
Mm-hmm.
You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving.
Now pause for a second. Did you hear that? 81 miles an hour in a construction zone. That's not just breaking the law. That's practically gambling with human lives. The judge makes it crystal clear no one is that important to justify that kind of speed. And here's a legal insight for you. Construction zones often carry double penalties. Why? Because workers are unprotected and accidents there are almost always catastrophic. Conley might think this is just a speeding ticket, but the courtroom sees it as a major safety issue. What do you think? Should speeding like this carry harsher punishments even if no one gets hurt, or is the judge already going too far?
Recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up.
This right here is where it gets fascinating. On paper, Conley just won. The trooper doesn't show, the ticket's dismissed. But watch how the judge flips it. Instead of celebrating, Conley gets blasted for her attitude, the rolling eyes, the refusal to take responsibility, the push for even more breaks when she already got one. Judges don't just rule on law, they rule on character too. And this moment is a classic example. The legal case may have evaporated, but her credibility took a massive hit. Quick question for you guys. If the officer doesn't appear, should the case always be dismissed, or should reckless drivers like this face a mandatory penalty anyway?
I'm looking in the background, never roll.
Okay, well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
This is the knockout punch. The judge reminds everyone watching that driving isn't some God-given right. It's a privilege. That privilege comes with rules, responsibilities, and consequences. When Conley rolled her eyes, the judge almost reset the case just to hammer the lesson home. And honestly, that's not just aimed at her. That's aimed at every driver who thinks they can speed, text, or blow through traffic laws without consequences. Courtrooms like this set the tone. Entitlement will crash harder than any car. If you were the judge, would you have dismissed the case on a technicality or made an example out of her?
Back. So we're going to begin in case number 25-4703FY. Mr. Ullum is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullum?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ullum's rights in this matter. In regards to the underlying charges, Mr. Ullum waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ullum stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and to counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ullum, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week.
Now we shift gears to Mr. Ullum, and this case shows just how unforgiving bond violations can be. He originally had a chance. The court set bond at $25,000, 10% down. That means if he stayed clean, he could have remained free while his case moved forward. Instead, he broke the rules. New charges stacked on top of old ones. And just like that, the court's patience ran out. The judge yanked his bond and sent him straight back to jail. And here's something important. When a defendant violates bond, it's not just about money. It's about trust. Once the court decides you can't be trusted, the doors to freedom slam shut quickly. What do you think? Should people get a second shot at bond if they screw up? Or is one chance already too generous?
And we'll make sure that the hearing is expedited. We'll move on to case number 25-4779SM. And Ms. Farrar-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Owen as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel.
The lecture didn't stop there. The judge hammered home the cold truth. Driving is a privilege, not a right. He didn't mince words, telling her she's not that important to jeopardize others. When she rolled her eyes like a spoiled teenager, the tension spiked. The judge threatened to reset the case entirely just to make his point. That's how you know he wasn't just talking to her. He was talking to every arrogant driver who thinks speed limits don't apply. Lesson 1, entitlement crashes hard in court.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pre-trial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Farrar-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No, Mr. Ulam. No, Mr. Ulam. No,
What address?
Mr.
What
Ulam.
address again? What address? I'm just confused. I just wanted to repeat I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you can't be at any address that Darcy Robinson is or may be. You may not be within 500 yards of her workplace or any address.
I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless and I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? Oh, man. You just took my phone. Hey, tell Darcy Robinson not to bomb me out again, too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Olam, and it's going to be a $25,000, 10%.
And there you have it. 2 defendants, 2 very different lessons, but the same bottom line. Arrogance and irresponsibility don't fly in court. Miss Conley may have dodged her speeding ticket thanks to a missing officer, but the judge made it clear. Next time, she may not be so lucky. And Mr. Ohm, his bond violations landed him right back behind bars, showing how quickly second chances vanish when you refuse to play by the rules. These cases remind us that the courtroom isn't just about laws. It's about accountability, respect, and the safety of others. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you won't want to miss what comes next.